Welcome to today's program, Civility, Do Lawyers Have a Duty to Negotiate in Good Faith? My name is Zach McGee. I'm a Senior Vice President in Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Our topic today is civility, and in particular, the question whether, as part of behaving more civilly toward each other, lawyers have a duty to negotiate in good faith. Of course, we are talking about civility today because California recently added 1 hour of civility in the legal profession training as a separate CLE requirement that its lawyers need to satisfy. This is the second program I have done in this area. The first one was an introduction to civility in the legal profession. So if you're interested in an overview of the topic, I suggest you check that one out. You'll probably decide to wait to do that until next year, because California lawyers only need 1 hour of civility in the legal profession CLE credit in each reporting cycle. But I thought I would let you know about my other program in case one of your colleagues might be looking for a program like that. In today's program, we will focus on how the California State Bar thinks lawyers should behave when we negotiate, and how that aspirational, non-binding guidance differs from the law and the legal ethics rules that actually govern lawyers when we negotiate. How the California State Bar thinks lawyers should negotiate is set out in Section 18 entitled Negotiation of Written Agreements of the California Attorney Guidelines of Civility and Professionalism that were adopted by the California State Bar back in 2007. The law of contracts and the law of fraud, plus the legal ethics rules and related formal ethics opinions, collectively comprise the standards that actually govern lawyers when we negotiate. And it is those binding rules, and those rules alone, that can subject lawyers to adverse consequences if they fail to follow them, in terms of potential civil liability and potential sanctions under the legal ethics rules. We will use a fun hypothetical negotiation between lawyers to illustrate the differences between the California State Bar's aspirational guidance that lawyers negotiate in good faith and the black-letter law and legal ethics rules that require only that lawyers refrain from knowingly making false statements of material fact or law, or otherwise engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Indeed, based on some of the guidance issued by the ABA Standing Committee on Ethics and Professionalism, even some dishonesty may be permissible, given the unique context in which negotiations occur and the expectations that most people, including most lawyers, have about certain types of statements made in that context, such as how much the other party values the subject matter of the negotiation. That guidance suggests that lawyers may be able to misrepresent things like that because no one expects what you say about how much you would pay for something in a negotiation is entirely truthful. But there are other things, such as your client's bottom line, that you may not misrepresent, according to that same guidance, even if the parties in a negotiation tend not to believe that either. Despite some nuances like that, the law and the legal ethics rules in general do a good job of setting standards for lawyers to follow when we negotiate. And at the end of today's presentation, you'll know what those rules require and what additional guidelines the California State Bar would like you to follow in the name of promoting civility. Then you can decide whether those guidelines are necessary or sensible and if you should follow them. Before we can dive into today's topic, some background on the California Attorney Guidelines of Civility and Professionalism, which I refer to throughout this program simply as the guidelines, is necessary. The guidelines, which were adopted 15 years ago to address a perceived lack of civility in the legal profession, start with the following introduction. Quote, "As officers of the court, With responsibilities to the administration of justice, attorneys have an obligation to be professional with clients, other parties and counsel, the courts, and the public. This obligation includes civility, professional integrity, personal dignity, candor, diligence, respect, courtesy, and cooperation, all of which are essential to the fair administration of justice and conflict resolution. These are guidelines for civility. The guidelines are offered because civility in the practice of law promotes both the effectiveness and the enjoyment of the practice and economical client representation. The legal profession must strive for the highest standards of attorney behavior to elevate and enhance our service to justice. Uncivil or unprofessional conduct not only disserves the individual involved, it demeans the profession as a whole and our system of justice. These voluntary guidelines foster a level of civility and professionalism that exceeds the minimum requirements of the mandated rules of professional conduct as the best practices of civility in the practice of law in California. The guidelines are not intended to supplant these or any other rules or laws that govern attorney conduct. Since the guidelines are not mandatory rules of professional conduct, nor rules of practice, nor standards of care, they are not to be used as an independent basis for disciplinary charges by the State Bar or claims of professional negligence. The guidelines are intended to complement codes of professionalism adopted by bar associations in California. Individual attorneys are encouraged to make these guidelines their personal standards by taking the pledge that appears at the end. The guidelines can be applicable to all lawyers regardless of practice area. Attorneys are encouraged to comply with both the spirit and letter of these guidelines, recognizing that complying with these guidelines does not in any way denigrate the attorney's duty of zealous representation." End quote. The guidelines consist of 21 sections that address civility issues in client relations and responsibilities to the profession, public, and administration of justice, in addition to civility issues and responsibilities in attorney-attorney relationships. I have included a copy of the guidelines in the written materials for this program so you can review them on your own to get a feel for what they cover overall. Today, we are focusing only on Section 18, which deals with the negotiation of written agreements. While the California State Bar very much would like you to follow its recommendations in this area and in all of the other 20 areas that the guidelines cover, it's critical to understand at the outset that the guidelines reflect how the California State Bar thinks lawyers should practice law. They do not create standards of conduct or care. They do not supplant any rules or laws that govern attorney conduct, and they cannot be an independent basis for imposition of discipline or a finding of malpractice. Now that civility is a CLE requirement in California, you are being required to learn about the guidelines, but you are not being required to follow them. There are several reasons why the guidelines are aspirational and not mandatory, but for our present purposes, all you need to know is that you are being asked to follow the guidelines and to make a voluntary commitment to do so by signing the optional attorney pledge that appears at the end of the guidelines, but you are not required to do so. The attorney pledge reads as follows, quote, "I commit to these guidelines of civility and professionalism and will be guided by a sense of integrity, cooperation, and fair play. I will abstain from rude, disruptive, disrespectful, and abusive behavior, and will act with dignity, decency, courtesy, and candor with opposing counsel, the courts, and the public. As part of my responsibility for the fair administration of justice, I will inform my clients of this commitment, and, in an effort to help promote the responsible practice of law, I will encourage other attorneys to observe these guidelines." End quote. Attorneys taking the pledge are asked to print their name, sign and date the pledge. Attorneys also are asked to encourage others to sign the pledge, including opposing counsel in cases they are handling. I'd be interested to hear if any of you who are viewing this program has been asked to sign the attorney pledge by opposing counsel, and if so, how you responded. So please reach out to me if you've had that experience. Because our topic today is, do lawyers have a duty to negotiate in good faith? We are going to focus on Section 18 of the guidelines, entitled Negotiation of Written Agreements. Section 18 provides that, quote, an attorney should negotiate and conclude written agreements in a cooperative manner and with informed authority of the client, end quote. Section 18 follows this general pronouncement with the following additional guidance, including several specific examples of behaviors it advises lawyers to avoid when negotiating. Quote, for example, A, an attorney should use boilerplate provisions only if they apply to the subject of the agreement. B, if an attorney modifies a document, the attorney should clearly identify the change and bring it to the attention of other counsel. C, an attorney should avoid negotiating tactics that are abusive, that are not made in good faith, that threaten inappropriate legal action, that are not true, that set arbitrary deadlines, that are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, or that do not accurately reflect the client's wishes or previous oral agreements. D, an attorney should not participate in an action or the preparation of a document that is intended to circumvent or violate applicable laws or rules. In addition to other applicable sections of these guidelines, attorneys engaged in a transactional practice have unique responsibilities because much of the practice is conducted without judicial supervision. For example, A, attorneys should be mindful that their primary goals are to negotiate in a manner that accurately represents their client and the purpose for which they were retained. B, attorneys should successfully and timely conclude a transaction in a manner that accurately represents the party's intentions and has the least likely potential for litigation. C, with client approval, attorneys should consider giving each party permission to contact the employees of the other party for the purpose of promptly and efficiently obtaining necessary information and documents, end quote. So, Section 18 of the guidelines expressly encourages us to negotiate in good faith, in addition to setting forth a number of specific things that it says lawyers should not do when we negotiate, such as setting arbitrary deadlines or using negotiation tactics that are abusive or are intended solely to take unfair advantage of a superior bargaining position. As you might expect, this is very different from what the existing law and legal ethics rules actually require of lawyers when we negotiate. We'll explore those differences with the help of a fun hypothetical negotiation among lawyers that's near and dear to my heart as a lawyer working in the entertainment industry in Los Angeles. In our hypothetical, we have an aspiring television producer and current coffee shop server, Alfonso Spears, who has an idea for a new reality TV show called Puppy Love. His concept? After an eccentric widow leaves her fortune to her prized labradoodle Kiki, 6 contestants compete to win Kiki's love and with it, her $5 million inheritance. And like all good treatments and pitches, it ends with hilarity ensuing. Ricky, aka Slick Rick Stratton, owns an upstart reality TV production company, Silver Spoon Productions. Flush with success from his breakout hit, Your Dingo Ate My Baby, Rick is always sniffing around for his next project. Over a decaf skinny no-foam latte, Rick invites Alfonso to pitch Puppy Love, and Rick accepts a detailed written treatment from Alfonso. Not entirely surprisingly, Alfonso never hears from Rick again, and that fall, a show called Dog's Best Friend premieres on the Animal Network. The show, which is produced by Rick and Silver Spoon, is oddly similar to Alfonso's concept for Puppy Love. What does Alfonso do? He goes and hires Kate Summers, who is an industry litigator, a self-proclaimed legal pit bull, to represent him in his dispute with Silver Spoon. In a barking letter, Kate accuses Silver Spoon of stealing Alfonso's idea for Puppy Love and insists that Alfonso receive proper creative credit on Dog's Best Friend, a salaried producing job, and a healthy share of the show's profits. Silver Spoon counters that Dog's Best Friend was created independently from Puppy Love, and the similarities aren't enough to state a legal claim anyway. Silver Spoon is represented by its sole in-house lawyer, Edward Stratton III, who happens to be Slick Rick's brother. Kate and Edward are now negotiating to try to resolve this dispute between Alfonso and Silver Spoon. Lastly, and importantly, while each is an industry veteran, they do not deal regularly with one another. This touches on something that we'll cover in more depth later, but we've purposefully created a situation where these folks are not going to deal with one another often. And the reason we've done that is because you tend to see sharper practices when negotiators are not concerned about facing one another later. Obviously, to the extent that these people deal with one another regularly, their conduct would be probably more circumscribed, more reasonable. They would be more concerned about their reputations. They would be concerned about any deceptive practices not being effective and therefore preventing them from competently representing their clients. So, it's important to note that they don't expect to see each other again, and I think that's going to explain a lot of the conduct that we will see in the hypothetical. Let's take a look at the first scene.
Listen, Edward, I took your call, but I'm not prepared to negotiate. If you don't accept in full the terms as proposed in our letter, we're moving forward with a lawsuit. I have no doubt any jury would award us triple what we asked for.
What's going on in this scene is pretty classic take it or leave it. Basically, negotiating by trying not to negotiate. Kate is trying to shut down any negotiation right off the bat by saying, I've made my demand, and if you don't agree to everything that I have said in my letter, we're going to file a lawsuit. Given that Kate's client has not authorized her to file a lawsuit, on the contrary, he has said very clearly that he wants to try to resolve this without any litigation. Kate is very clearly getting ahead of her client. Because Kate is making a threat to Edward that is unauthorized, you could view that as bad faith negotiation. Some of you might think that the act of making any threats in a negotiation, whether they are authorized by your client or not, qualifies as bad faith. How should we think about this scene? The first issue this scene raises is the title of our program today. Do lawyers have a duty to negotiate in good faith? The short answer is no. The longer answer is that in general, in the United States, there is no independent duty to negotiate in good faith because neither the law nor the legal ethics rules require the parties to negotiate in good faith. We do need to distinguish a few things. If you're under a contractual duty to negotiate, let's say you have a first negotiation provision in a contract or a duty to negotiate an extension, for example, the law would imply a duty of good faith in the performance of that contractual obligation. As we all remember from first-year contracts, the law implies a duty to perform all contractual obligations in good faith, which then would include contractual duties to negotiate in cases where such a duty is part of the contract. But that's a specific case, and absent that, there is no general duty of good faith to negotiate. Now that said, there are two caveats to this. The first is Section 18 of the guidelines that we just saw that suggests that lawyers should act in good faith when they are negotiating. But that is not something that's binding on lawyers, even in California. The ethics rules, as we'll see in a second, are the things that bind lawyers, not these aspirational guidelines, and we'll talk a lot more about the relationship between the two later. The other caveat is that we're talking here about U.S. law and the law in the various U.S. states. In some European jurisdictions and in China, for example, there can be a general duty to negotiate in good faith. Setting those caveats aside, the fact that there is no general duty of good faith in negotiating is a point that's very often misunderstood among lawyers and even some judges. Lawyers often levy charges against one another of negotiating in bad faith, but usually they're just describing some conduct that they don't like or that they find takes a sharp edge, and it's not really talking about a violation of some independent duty to negotiate in good faith. There is no independent duty, absent a contractual obligation to do that in the United States. Because Section 18 of the guidelines asks lawyers to negotiate in good faith, it would represent a change from what existing law and legal ethics rules require. So that's the fundamental thing you should take away at the outset. Now, even though I don't think lawyers need the guidelines, or that we should commit to follow them, for reasons I will cover later, that is not to say that I think lawyers should negotiate in bad faith. On the contrary, I think it's a better practice to negotiate in good faith because in most cases, in my experience, you're going to have a better result if you do negotiate in good faith. You're going to form better relationships. You're going to have better encounters with those people later. The contract is more likely to go smoothly if the process has gone smoothly. If you're engaging in bad faith in a negotiation just to get the other side to capitulate, like Kate is trying to do with Edward here, that may not produce A, the best agreement, or B, a durable agreement, i.e., one that isn't going to be challenged later, isn't going to be the subject of a claim, or just isn't going to be performed well by the side who feels that they were taken advantage of by some bad faith negotiation. You also risk doing significant damage to your reputation if you negotiate in bad faith, and that can negatively impact your ability to get deals done in the future, which is yet another good reason to avoid negotiating in bad faith, using dirty tricks, or engaging in other sharp practice when you negotiate. This is another topic we'll explore in some detail later. So, if there is no general duty to negotiate in good faith imposed by the law or the legal ethics rules, what are the binding rules that govern lawyers when we negotiate? The place to start is with the ABA model rules, which are now followed by the vast majority of states, including California and New York, and specifically ABA Model Rule 8.4, which provides that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. The way I think about this is, in being a zealous advocate for your client when you negotiate, you're not allowed to lie, which is to say you're not allowed to make a false statement of material fact. You're not allowed to commit fraud. You're not allowed to commit deceit. You're not allowed to misrepresent. This is very important, and lawyers need to know that if you're engaging in this conduct when you negotiate, lying, misrepresenting facts, being deceitful, you are violating the legal ethics rules and could subject yourself to discipline. You also could open up your client to an action for fraud. This is a good place to make a distinction between the ethics rules and a cause of action for fraud or for misrepresentation or deceit. We're going to look at these hypotheticals and analyze them to see, okay, have you arguably violated your ethical duties, and what might be the remedy for that? One other thing to worry about is a possible cause of action for fraud. If you've committed an act in a negotiation, whether it's an ethical violation or it isn't, the other side could sue your client for fraud. They could make a claim that you've made a false statement, that it was material, that they relied upon it to their detriment, and that they've suffered damages. Because there's always the possibility that the other side could bring a fraud claim based upon your conduct in a negotiation, I would urge you to follow the guidance that I'm presenting to you today. Another important thing you should be concerned about if you lie, misrepresent facts, and act deceitfully in negotiations is your reputation. You're going to be dealing with a lot of the same people in your practice over and over again. I work in Los Angeles, and you might think, well, that's a huge metropolitan area. I'm sure there's hundreds of thousands of lawyers. But in reality, it's a pretty small community when you're talking about the entertainment industry in particular. It's rare that I deal with somebody that I don't know or where I don't know someone who knows that person. And if you get a reputation in your community for sharp practice, that could really be a detriment to you and to the clients that you represent. Let me explain what I mean. If I'm negotiating with somebody who I know has a reputation for sharp practice, I'm going to be extra careful with that person. There might be reasonable accommodations that I would make for people that I deal with regularly who I feel are straight shooters. With some of those folks, I could get a deal done in a day and feel comfortable relying on an email confirmation even before the contract is done because I know and I trust them. If I don't trust you, I will make you document every statement you make to me that I can't independently verify before I will rely on it. And that process can take a very long time. I'll also likely take a harder line against you if I believe you're a shady negotiator, because I expect you'll be doing the same in your dealings with me. If this type of negotiation takes longer than your client wants and ends up delivering less value to your client than another lawyer could have obtained, you will end up being less effective for your client precisely because you have a reputation for sharp practice. Our next stop is a critical rule for lawyer negotiators, ABA Model Rule 4.1. This is a rule that we will come back to again and again. Here is what the rule says, quote, "In the course of representing a client, a lawyer shall not knowingly, A, make a false statement of material fact or law to a third person, or B, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, end quote. The language starts, quote, "In the course of representing a client, a lawyer shall not knowingly," end quote. Then we have a couple of examples of things that the lawyers may not do. Let's look closely at the language used in the rule because each of the words turns out to be quite important. One key word here is knowingly. The rule provides that a lawyer shall not knowingly make a false statement of material fact or law to a third person in Section A, and then in Section B, knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. If a lawyer did not know a statement of fact was false at the time he or she made it, that conduct would not violate ABA Model Rule 4.1. We're also only talking about false statements of fact. We're not talking about opinions. So this pie is really good is going to fit into one category, and there are 3 pieces of pie when there are in fact 4. That is going to fall into a different category. And as simple as that example may sound, I think people would be surprised at how often opinions are confused with statements of fact. And it's not just any type of statement of fact. It has to be a material fact. So it may well be, "I'm happy to negotiate with you, but I have an appointment today at noon." If that's untrue, is that a statement of material fact? Or is that really a statement about the context? Is that a statement about something that's not material? It may be a very bad idea for me to do that in terms of our relationship, but at the same time, is that going to be grounds for an ethical violation? I think people would argue that that kind of statement is not material. Returning to our hypothetical and applying the standards that we just reviewed, I think it's pretty clear that Kate's conduct in making a take-it-or-leave-it offer isn't a violation of either the law of fraud or the legal ethics rules, at least if we put aside for the moment the fact that her client has not authorized her to file a lawsuit. For both potential fraud claims and legal ethics violations, the first question to ask is, does Kate make any material false statements of fact? If you look closely at what Kate said, "Listen, Edward, I took your call, but I'm not prepared to negotiate. If you don't accept in full the terms as proposed in our letter, we're moving forward with a lawsuit. I have no doubt any jury would award us triple what we're asking for." Everything is stated in terms of what she intends to do or not to do, i.e., not to negotiate and to file a lawsuit, or what she thinks a jury will award her client, which is an opinion or a prediction of future events and not a fact. Now, you could argue that in light of what Kate's client told her, that he did not want to file a lawsuit, Kate's statement of her present intention not to negotiate and intent instead to file a lawsuit is in some sense false, but you are never going to be able to prove the falsity of someone's present intention in order to establish either a fraud claim or a violation of the legal ethics rules. If her lack of client authorization ever came to light, and how would it, because communications between Kate and Alfonso are protected from disclosure by the attorney-client privilege, Kate would simply pivot and argue truthfully that she was giving Edward a take-it-or-leave-it offer as a negotiation tactic or a bluff in an effort to win the best deal for her client. Neither the law of fraud nor the legal ethics rules is going to punish a lawyer for employing such a tactic in the context of a negotiation, even if Edward ends up capitulating to Kate's threat. Now, this is very different from a case where a lawyer makes a false statement of material fact. For example, telling the other side that the car you are selling hasn't been in any accidents, when in fact it has. That could form the basis for a fraud or a legal ethics violation under ABA Model Rule 4.1. So I don't think Kate is risking catching a fraud claim for her client or a violation of the legal ethics rules for herself in this first hypothetical. But what result under the guidelines? Does Kate's conduct constitute uncivil negotiation of written instruments under Section 18 of the guidelines? I think Kate's conduct almost certainly violates those standards. Recall that Section 18 advises lawyers to, quote, negotiate and conclude written agreements in a cooperative manner and with informed authority of the client, end quote. A great many negotiation tactics, or as some might call them, dirty tricks, very likely would be seen to violate the standard to negotiate cooperatively. Indeed, giving the other side a take-it-or-leave-it proposal is probably one of the better examples of a tactic that violates the standard to negotiate cooperatively, because you are refusing to negotiate and threatening the other side with consequences if they refuse to accede to your demands. You also could find a violation of the, quote, informed authority of the client, unquote, clause in this case, because Kate's threat is expressly contrary to Alfonso's desire to resolve the dispute without litigation. Section 18 follows up this general pronouncement with the following additional guidance, including several specific examples of behaviors it advises lawyers to avoid when negotiating, including, quote, an attorney should avoid negotiating tactics that are abusive, that are not made in good faith, that threaten inappropriate legal action, that are not true, that set arbitrary deadlines, that are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, or that do not accurately reflect the client's wishes or previous oral agreements, end quote. Once again, Kate's tactics very likely could be viewed as abusive, not made in good faith, threatening legal action, setting arbitrary deadlines, intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, and not accurately reflecting the client's wishes or previous oral agreements. So, I think Kate's goose is cooked if we are measuring her conduct against the non-binding civility guidance reflected in Section 18 of the guidelines. But is that the result that we want? I don't think so, for at least 4 reasons. First, the guidance set forth in Section 18 of the guidelines, in addition to most of the other 20 sections, is far too vague to be applied consistently or to give lawyers adequate notice of what conduct is okay and what conduct is being proscribed. While Kate's take-it-or-leave-it proposal might be seen as abusive, not in good faith, or intended solely to gain an unfair advantage, or take unfair advantage of a superior bargaining position, when viewed from the perspective of Edward or Silver Spoon Productions, Kate might view her proposal as completely reasonable in the context of a negotiation, particularly if Kate had discussed her plan in advance with Alfonso, and Alfonso had specifically authorized her to use it. In negotiations, like in poker, the propriety of using certain tactics like bluffing is in the eye of the beholder. One party might call abusive or bad faith, the other party might view as perfectly appropriate. While it's beyond the scope of today's presentation, the main reason that the guidelines are aspirational only and not mandatory is because they are too vague to be enforceable. If the guidelines were mandatory and lawyers could be punished for violating them, there is little doubt that a court would strike most, if not all of them down, on void for vagueness grounds, in violation of the Due Process Clause. This is precisely what happened with a legacy rule in California that required lawyers to, quote, abstain from an offensive personality, end quote, in the practice of law. So when the guidelines were adopted, everyone understood that they could be aspirational only and not mandatory. As I said at the start, now that civility is a CLE requirement in California, you are being required to learn about the guidelines, but you are not being required to follow them. What is the benefit of a set of guidelines that are so vague that reasonable minds would disagree on whether certain conduct violates them or not, and even if it did, the guidelines can't be enforced by anyone anyway? To my mind, there is none. Second, that Kate's use of a take-it-or-leave-it proposal would be viewed by many as a violation of Section 18 of the guidelines is a problem because it could chill conduct by Kate and other lawyers that we in fact don't want to discourage. I'm making an overbreadth argument here, so let me explain what I mean. What if Kate's take-it-or-leave-it proposal wasn't a tactic at all? Let's say Alfonso was a multimillionaire and was committed to vindicating his rights by obtaining a final judgment after trial against Silver Spoon Productions, no matter what the costs and no matter what Silver Spoon might offer him to settle. In that case, Kate's only option is to make Edward a take-it-or-leave-it proposal because that is exactly what her client wants her to do. This is also why making a take-it-or-leave-it proposal isn't going to cause Kate or Alfonso to catch a fraud claim or to put Kate at risk of committing a legal ethics violation. If your client demands what he demands and is unwilling to take a penny less, it can't be fraud or a legal ethics violation for you, as his lawyer, to communicate that demand to the other side. I also think you have the same overbreadth problem, even if Kate's take-it-or-leave-it proposal were a tactic, but one that was specifically authorized by Alfonso. If your client wants to play hardball in a negotiation, most lawyers would view that as their obligation, or at least not a legal ethics violation, to follow their client's wishes and execute their client's preferred strategy. That said, I don't think there is anything wrong with a lawyer who wants to try to talk a client out of a particular course of action. Indeed, ABA Model Rule 2.1 says that a lawyer may, not must, but may, advise a client with respect to morality, so you have a basis to counsel a client on grounds that are not strictly legal. So that's an option that is open to you. In fact, I easily could see myself trying to talk Alfonso out of asking me to give Edward a take-it-or-leave-it proposal, not because I think it's unethical, but because I think it's unlikely to achieve the result Alfonso wants. Most people don't react well to being threatened, and so making such a proposal likely won't result in Edward or Silver Spoon agreeing to our demands. On the contrary, it probably will cause them to harden their position, which means that a lawsuit will be filed and likely pursued for a while, causing both sides to incur hassle and expense before the parties decide to try again to negotiate a settlement. That is probably not in Alfonso's interests, and so I might make that point to him in an effort to talk him out of taking such a hardline approach. But at the end of the day, if the client wants to play hardball after I inform him of the risks that the tactic won't achieve the result the client intends, I wouldn't have an issue executing on that strategy, as long as I don't believe it violates the law or the legal ethics rules. That is why I don't think the guidelines are a good idea. Third, Section 18 simply serves to muddy the waters between what conduct lawyers can engage in when we negotiate and what we cannot by virtue of layering on vague, additional, and non-binding guidance on which reasonable lawyers might disagree in terms of its application to any particular set of facts. While the law of fraud and the legal ethics rules are not a perfect fit for governing the conduct of lawyers when we negotiate, and we will see that this is true when we tackle our next hypothetical shortly, the existing law and the legal ethics rules do a pretty good job. The last thing we need is another set of rules to create confusion in an area that is already confusing enough because of the many different tactics lawyers can use in negotiations. Within the outer bounds established by the law of fraud and the legal ethics rules, lawyers should be allowed to negotiate as they see fit. I don't mean to suggest that lawyers should use dirty tricks or engage in other sharp practice when we negotiate, even if the particular tactic doesn't violate the law or the legal ethics rules, because I think that lawyers who do that suffer damage to their reputations that actually make it harder, not easier, for them to achieve the best results for their clients in negotiations. I think that lawyers can and should make up their own minds on their choice to negotiate, taking into account the law, the legal ethics rules, and potential reputational consequences, and that we don't need Section 18 of the guidelines to make sure that we act as professionals. Finally, we don't need Section 18 to help us deal with lawyers who use dirty tricks or engage in other sharp practice in negotiations, because we lawyers are perfectly capable of dealing with those tactics ourselves, provided that you've had a little training in this area. Besides, there is no judge or state bar official present in your negotiations, so even if you could show that the other side's conduct violates Section 18 or even the law or the legal ethics rules, you can't appeal to anyone in the moment to take action on your behalf anyway. Indeed, I've devoted considerable time in each of my negotiation ethics for lawyers programs to teaching lawyers techniques they can use to counter dirty tricks when the other side attempts to use them on you. You can do this very effectively and without violating the law or the legal ethics rules yourself, once you are able to spot the dirty trick and have had some training on how you might respond. If you're interested in learning some of these techniques, please feel free to check out any of the programs in this series that are likely available on the service where you're watching this one. To give you a flavor of some of this practical advice, let's think about how Edward could counter Kate's take it or leave it proposal here. One thing Edward could do is simply ignore the threat and try to move past it by saying something like, "Kate, my client and I don't respond to threats, but I'm happy to continue to discuss your client's claim to see if we can resolve this dispute." There isn't anything wrong with ignoring threats someone is making to you, but it may or may not be effective depending on the person that you're dealing with on the other side. Another, better alternative is something I describe as painting a picture for the other side. One of my favorite techniques is to say something like, "Okay, I hear you saying that if we don't agree to this in exactly what you've said in your letter, you're going to file a lawsuit. Well, let me take you through what that's going to do on my side. When I report that back to my client, the head of the studio, he's going to say, okay, we're never going to negotiate with this person. We're never going to get any kind of credit for having developed this idea, and we're going to fight this until the very end, and they're going to go broke with their legal fees." If you give the other side a sense of, you've set this in motion, this chain of events, let me paint for you a picture of how that's going to play out. If that's not how you want this to end, we need to work together to suggest some other approach. I think it's often a very persuasive and powerful technique. Another possible response from Edward is treating Kate's threat as unauthorized, and it's clever to put Kate in a box and say, "Has your client actually authorized you to file a lawsuit?" This is a very good technique because it then forces Kate either to tell the truth and say no, or to lie. There are many other possible responses, but the last one I want to mention is the most creative and likely the best, which is to suggest a tolling agreement. It's an obvious and very wise choice in this circumstance because with the tolling agreement, you're giving something to the other side. They've worked a concession out of you that you are now agreeing to toll, and you also avoid any issue of requiring a lawsuit to be filed right away. That's a good example of how you can get creative. Everybody gets a little something, and that gives you more time to negotiate without a gun to your head or the need to call the other side's bluff. Circling back to my original point, we don't need Section 18 of the guidelines to protect us when we negotiate, because we can protect ourselves once we receive a little training in negotiation strategy, and there is no judge or state bar committee available to protect us anyway. Let's turn now to our second hypothetical.
My client Alfonso is a true artist and dog lover. He doesn't care about the money. What he wants is credit for creating Dog's Best Friend and to work on the show as a producer.
This scene illustrates very clearly the question whether lawyers can misrepresent their client's true goals and objectives in a negotiation. As you see from the slide, Alfonso had told Kate that he only cares about receiving a large cash settlement from Silver Spoon, and that he hates Dog's Best Friend and how it turned out, and he doesn't want to be associated with it in any way. Kate is using the notion of a producing credit as a way to hopefully increase the settlement value of the claim and ultimately get more money for her client through this misrepresentation, because she believes the studio would be unwilling to give her client a producing credit under any circumstances. The idea is, by demanding something that she believes the studio would never agree to, it's a way to drive up the settlement value. Now, her client wants exactly the opposite. Do Kate's arguably false and, at the very least, misleading statements violate the law or the legal ethics rules? What about Section 18 of the guidelines? You might be surprised to learn that Kate's statement likely would not be held to violate the law or the legal ethics rules, but they likely would violate Section 18. In order to understand this result, we need to return to ABA Model Rule 4.1 and more specifically to the comment to that rule. As important as ABA Model Rule 4.1 is, the comment is arguably more important because it is attempting to unravel what it means to not knowingly make false statements of material fact in the context of negotiations. The comment begins by observing that, quote, under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category, and so is the existence of an undisclosed principal, except where non-disclosure of the principal would constitute fraud. End quote. Interpreting ABA Model Rule 4.1 and the comment, the ABA's Standing Committee on Professional Ethics in 2006 issued Formal Ethics Opinion number 06-439, which provides a lot of detailed guidance for lawyers engaged in negotiations. The opinion states directly that lawyers do not violate the model rules by misrepresenting, exaggerating, or downplaying several independent categories, including a settlement position or a willingness to make concessions, a client's negotiation goals or objectives, the strengths or weaknesses of factual or legal positions, the value of the subject matter of the negotiations, or the lawyer's or the client's confidence in the availability of alternatives. So, we have a list of categories of statements that don't violate ABA Model Rule 4.1 according to the ABA Ethics Committee. You likely don't find this guidance surprising, because few experienced negotiators believe the other side when they tell you that their client isn't interested in settling for less than $1 million, particularly when you settle the case an hour later for $50,000. But one part of ABA Formal Ethics Opinion number 06-439 is surprising, even to experienced negotiators. The opinion states that, quote, a party's actual bottom line or the settlement authority given to a lawyer is a material fact that a lawyer may not misrepresent in a negotiation, end quote. Similar to a lawyer's statements about a client's settlement position, I think most lawyers don't actually believe it when they hear another lawyer say, my client's bottom line is $4 million. Does anyone ever believe that? The opinion says, and this is important, that a lawyer may, quote, downplay a client's willingness to compromise or present a client's bargaining position without disclosing the client's bottom line position in an effort to reach a more favorable resolution, end quote. So it creates this distinction between my client's bottom line is $1 million as opposed to we'd never accept that little money to settle our claims. Applying the standards set out in ABA Formal Ethics Opinion number 06-439, making a false statement about your client's bottom line violates Model Rule 4.1. I would point out that even though a false statement about your client's bottom line is unethical, according to the ABA committee, I don't think it ever could rise to a fraud claim, because I don't think anybody could show reasonable reliance upon that type of statement. Based on the above guidance, Kate does not violate the law or the legal ethics rules by misrepresenting Alfonso's negotiation goals or objectives, and because she never said anything about Alfonso's bottom line, Kate can't be at risk of violating the legal ethics rules by misrepresenting her client's actual bottom line. I'm very confident in this conclusion, but because I am likely speaking to an audience of California lawyers, I need to add two caveats. First, while I am focused today on the ABA model rules, which nearly all states have adopted in some form or another, including California, I would be remiss if I didn't make a couple of comments about the legal and ethical standards that apply to California lawyers when we negotiate. While California follows the ABA model rules, California has on its books 3 statutes that predate its adoption of the ABA model rules that could be read to impose greater obligations on California lawyers than we find under the model rules. The first statute is California Business and Professions Code Section 6068, which requires, among other things, that an attorney, quote, employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, end quote. The second statute is Business and Professions Code Section 6106, which states that an attorney who commits any act of moral turpitude or dishonesty, whether or not in the course of the attorney's conduct as an attorney, is subject to disbarment or suspension. The third statute is Business and Professions Code Section 6128A, providing that, quote, every attorney is guilty of a misdemeanor who is guilty of any deceit or collusion or consents to any deceit or collusion with intent to deceive the court or any party, end quote. So, while you have the ABA Ethics Committee saying that you don't violate Model Rule 4.1 by making false statements about your client's negotiation goals or objectives, you have statutes in California saying attorneys may employ, quote, only those means as are consistent with truth, end quote, and expressly prohibiting them from engaging in dishonesty or deceit. While I believe the California State Bar and its courts would look at the guidance promulgated by the ABA when judging the conduct of lawyers when we negotiate, particularly now that California has adopted the ABA model rules, you should be aware that these other statutes exist where the language is admittedly vague, but also pretty absolute in requiring attorneys to employ those means only as are consistent with truth. The second caveat is, of course, Section 18 of the guidelines, which we've been discussing here today. While the guidelines are aspirational only, there is little doubt, once again, that Kate's misleading statements would violate Section 18. Apart from Section 18's general pronouncement that, quote, an attorney should negotiate and conclude written agreements in a cooperative manner and with informed authority of the client, end quote, you also could find fault with Kate's misrepresentations under the language of Example C that advises lawyers to avoid negotiating tactics that are, quote, not made in good faith, that are not true, and that do not accurately reflect the client's wishes. In our second hypothetical, just like the first, we have statements by Kate that don't violate the law or the legal ethics rules, but that would violate Section 18 of the guidelines. For the same 4 reasons we discussed earlier, I don't think this is the result that we want, or that we need Section 18 to police the conduct of other lawyers when we negotiate. Similar to the first hypothetical, Edward doesn't need Section 18 to protect him from Kate's misleading statements, because he is fully capable of doing that himself in terms of how he responds. For example, Edward simply could respond in kind by misrepresenting Silver Spoon's negotiation goals with something like, we could bring Alfonso on as a producer, but we can't afford to pay him anything by way of a cash settlement. Another, probably better response would be to test Alfonso's true negotiation goals by responding with something like, so, Alfonso would rather have credit and a 1-year producing job at a salary of $50,000 than a $50,000 cash settlement with no credit or producing job? A response like that is likely to smoke out Alfonso's true interest in getting the most money he can and his lack of interest in working as a producer on the series. With a little negotiation training and some creative thinking, Lawyers are fully capable of protecting themselves against dirty tricks or other sharp practice by other lawyers in a negotiation. We don't need Section 18 to do that for us, and even if we did, there is no judge or state bar official present when we negotiate to enforce these rules. We lawyers are on our own, but that's how it always has been, and I simply don't think we need a change. I enjoy hearing from lawyers who disagree with me, so if that describes you, please reach out to me and perhaps we'll have a lively debate. Let's turn now to our final hypothetical.
Kate, we've got ironclad evidence that my executive Rick created Dog's Best Friend independently of the puppy love pitch. Your client's testimony can't compete with our third-party witnesses and contemporaneous records.
As you can see from the slide, the ethical issue here is that Edward has no evidence that Rick created Dog's Best Friend independently of puppy love, apart from Rick's own self-serving testimony. This example turns out to be pretty easy. This is the clear, dirty trick. It's making up material facts out of whole cloth. We use all these euphemisms, but let's just call it what it is. It's flat out lying. It's clearly unethical, and it's clearly fraudulent. It's false because there is no third-party witness. There are no contemporaneous records, and there's not going to be any ability here to hide behind the concept of materiality. Independent creation is highly material in idea theft cases. In fact, it's going to be the entire defense, and so we can't pretend that that's not going to be a problem. Edward's objective in saying this is to give the impression that his client has a strong alternative to making a deal with Kate, which always is highly material in a negotiation. So, you have clear violations of ABA Model Rules 4.1 and 8.4, plus a potential claim for fraud in the event Kate chooses to settle Alfonso's claims in reliance on Edward's false statements, although Edward would dispute that Kate's decision to rely solely on his statements that he has evidence to prove that Silver Spoon independently created the show, rather than to ask to see the proof, was reasonable. What about Section 18 of the guidelines? Lying to the other side is probably the clearest example of a tactic that violates the standard to, quote, negotiate cooperatively, end quote. Lying also violates several of the examples listed in Section 18, including to avoid negotiating tactics that, quote, are not made in good faith, are not true, and are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, end quote. Accordingly, in this example, we have conduct that clearly violates the law, the legal ethics rules, and Section 18 of the guidelines. So why do we need the guidelines? In our prior two hypotheticals, the guidelines sought to proscribe conduct by lawyers in negotiations that are not prohibited by the law or the legal ethics rules. I criticized the guidelines in those cases for muddying the waters with respect to providing clear guidance for lawyers. Here, I'm criticizing the guidelines because they're simply piling on to prescribe conduct that already is prohibited. I also believe, like I did in our first two examples, that lawyers don't need the guidelines to help us in negotiations when the other side is lying to us or otherwise engaging in dirty tricks or sharp practice. To prove my point, here are two very smart things that Kate could say in response to Edward's lies, each of which is legal, ethical, and would not violate the guidelines.
Wow, it sounds like you've got all your ducks in a row. So who are your witnesses, and what records do you have? You realize that your claim that Dog's Best Friend was created independently of anyone else's ideas, including my clients', is important to us, and we're relying on that in making this deal with you.
In the first example, what Kate is doing is asking for specifics. That's a great way to force the other side into making a material false statement, or in this case, more material false statements. It's a very effective technique to ask, what records do you have? Who are your witnesses? In terms of delivering that message, one also can take the people out of it and make it more impersonal, such as, oh, we always verify. It's our policy. We always verify. Because maybe the other person may say, what, you don't believe me? You think I'm lying? And then you could say, no. I'm not saying that. I'm just saying we have this policy where we just have to verify. It's our company policy. While we don't have time today to talk in depth about negotiation strategy, and if you're interested in that, feel free to check out one of my Negotiation Ethics for Lawyers programs. It's always a good idea in negotiations to ask a lot of questions. This is generally true because it helps you uncover the interests that underlie the positions the other side is taking. Can you explain why you're asking for X? Which helps you to find alternatives that satisfy those interests in cases which you're not prepared to give the other side X. But it's particularly important when you think the other side is lying to you or engaging in other sharp practice, as Kate is doing here. In the second example, Kate is memorializing Edward's statements and making it clear that they are, in her view, material and that she is relying on them. She's effectively closing off these loopholes that otherwise might allow someone to escape liability for fraud or to escape from an ethical charge by saying, I hear what you're saying and I regard that as material, and we're relying on that in agreeing to make a deal with you. It's a way of locking in the other side, and if the other side is not going to play the highest risk game, may cause them to back down. And if they do back down, then you've gotten a lot more information. In this case, that they don't have any records or witnesses. It's a very effective response and a good technique to use. A related way to deal with this, in addition to getting the other side to confirm what is a material representation of something that you're signaling that you're relying upon, is actually to transfer the risk by putting the statements as express representations in the settlement agreement, so that if the other side breaches it, you have a breach of a representation and you'd be able to access indemnification. No matter which of these two responses she chooses, or any number of other very effective options that we don't have time to discuss today, Kate is perfectly capable of dealing with Edward's lies in the context of the negotiation. Once again, we don't need the guidelines to police Edward's conduct, and there is no judge or state bar official in the negotiation to enforce them anyway. We're very close now to the end of today's program, where we learned about the existence of a set of civility guidelines entitled California Attorney Guidelines of Civility and Professionalism that the State Bar adopted in 2007, and more specifically, Section 18 of the guidelines that addresses the conduct of lawyers when we negotiate. Importantly, the guidelines are purely voluntary. They do not create standards of conduct or care. They do not supplant any rules or laws that govern attorney conduct, and they cannot be an independent basis for the imposition of discipline or a finding of malpractice. But they reflect how the California State Bar thinks that we lawyers should practice law. Now that civility is a CLE requirement in California, you are being required to learn about the guidelines, but you are not being required to follow them. And as a result of today's program, you now know everything you need to know about the guidelines. It's up to you whether you think they are wise or necessary and whether you choose to follow them. We also learned a lot about the law and the legal ethics rules that govern the conduct of lawyers when we negotiate. We've seen the general rules that require lawyers to be candid in their dealings with others. That's ABA Model Rules 8.4 and 4.1. These rules establish clear bounds that you must stay within, such as the prohibition on misrepresenting your bottom line or the settlement authority that you have been given. In practice, lawyers can and should speak of your client's inclination toward a potential agreement and not his or her bottom line. What else have we learned that is clear in this area? The rules do not expressly bar attorneys from misrepresenting facts or law if they are not material. The rules also don't prevent attorneys from misrepresenting their opinions or intentions or state of mind. The rules do not preclude lawyers from misrepresenting their settlement positions or willingness to make concessions. If you hear an attorney claim that their client is not willing to make any concessions, you can hear that and know that it is not going to be an ethical violation, and it very well may be misrepresented. This brings us back to ABA Formal Ethics Opinion number 06-439, which says that the lawyer you are opposing, without violating the ethical rules, can misrepresent her client's goals, the client's objectives, the strengths and weaknesses in the client's position. The value of the subject matter may also be misrepresented to you, and the lawyers you're facing may also misrepresent their confidence in the availability of alternatives. Finally, apart from the legal ethics rules, there is the law of fraud that would allow the other party to make a claim in cases where the lawyer on the other side, in a negotiation, made false statements that were material and upon which the other party relied to their detriment and suffered damages. As this summary, I think, illustrates, there is a solid body of governing law and legal ethics rules that already serves to regulate the conduct of lawyers when we negotiate. We don't need or want Section 18 of the guidelines to pile on in cases where the conduct at issue is already a violation of the law or the legal ethics rules, as we saw in the third hypothetical, or in the first two hypotheticals, to proscribe conduct that is not a violation of the law or the legal ethics rules. At the end of the day, you will decide how to behave when you negotiate, and as I mentioned earlier, potential damage to your professional reputation is something you must consider whenever you might be tempted in a negotiation to use a dirty trick or to engage in other sharp practice. In my experience, dirty tricks and sharp practice are not nearly as effective as you or your client might think they will be, and this is particularly true if the lawyer on the other side knows how to counter them. And in most cases, you'll only end up disadvantaging yourself and your client if you get a reputation for being a shady negotiator. I hope you enjoyed today's program, and thanks for joining me.